I felt a disturbance in the force, like dozens of Disney lawyers laughing in unison. According to The Hollywood Reporter, Marvel is suing the estates and families of several comic book creators in order to keep the copyrights to characters like Spider-Man, Doctor Strange, and the Avengers. These 5 lawsuits are a response to efforts like those by the Ditko estate to get ownership over the copyrights under the termination provisions of copyright law. The way it works is that, quote, authors and their heirs can reclaim rights once granted to publishers after waiting a statutory set period of time. According to the termination notice, Marvel will lose rights to its iconic character, in this case Spider-Man, in June 2023. Several other estates and family members have done the same thing, such as Larry Lieber on behalf of his brother Stan Lee. Now, settle down. I know what you're thinking, but it's never going to happen. For one, they're being represented by Mark Toberoff, who represented Superman creators Jerry Siegel and Joe Shuster when their families tried to do the same thing with DC Comics, which failed. So you might want to pick another lawyer, especially since Disney hired Dan Petruccelli, the same guy who beat Toberoff in the Superman case. Petruccelli is probably sitting there like, According to the article, the litigation hinges on the Marvel method, which was a method Stan Lee used when writing comics. Because he wrote so many books, he couldn't write a full script for all of them. Instead, he'd write a short treatment and then the artist would flesh it out. Stan Lee would then come in and add the dialogue. Depending on how much or how little Stan Lee wrote, much if not most of the book may have been effectively written by the artist. However, all the creators, including Stan Lee, were technically work for hire at Marvel, making the company the overall, or in legal terms, statutory author of the books. The best way to think of it is that Marvel is the master, and the creators are the apprentice. The master can have the apprentice work on a piece, but the finished work is attributed to the master. This gets tricky though when the apprentice does all the work. Can you really claim that the company Marvel wrote and drew anything? Contrary to what some Republicans may think, corporations aren't people. They don't have hands to type, write, or draw. It's hard to argue that the company should get credit for the work of individuals, especially when that company advertises and sells that work based on those individuals. The creators should be compensated for their work and the money made from it for however long money is made from it. That said, they did agree to give the work to Marvel. That was either part of the spoken agreement or written into a physical contract. It's a terrible deal, but Marvel wasn't hiding this from anyone. It was well known in the comic book industry that if you created something for any publisher, the publisher owned it, not the actual creator. Siegel and Shuster were the poster children for this, and everyone knew about how they got shafted by DC Comics by the time Ditko worked at Marvel. Of course, some of these guys got terrible deals and were taken advantage of by the publishers, or as a capitalist would say, nothing to see here. But I'm more on the creator's side than the company side. However, as a Hollywood Reporter mentions, this has never worked. The 2 cases where this had the best chance of winning were with Kirby and Siegel and Shuster, all of whom were reamed by their publishers, Kirby by both Marvel and DC twice, and the cases failed. Every attempt at this has been shot down by the courts or settled out of court. And keep in mind, Disney has better lawyers than Warner Brothers and billions more dollars at stake. There's no way in any reality that Disney would let anyone get control over their most popular characters. Hell, they wouldn't even give up unpopular characters just to avoid setting precedent. I just don't see this working, but even if it did, what would the families do with the copyright? They would own the characters, but not necessarily the books, and definitely not all the characters who appeared in those comics. They also wouldn't own any of the trademarks to these characters, so it's difficult to see what they could do with them. How would you make bank on Spider-Man if you own the copyright to his character but not the trademark to his name or his costume? Their best option would be to allow Disney to continue to use the copyright characters. You'd be a fool if you didn't. Even if you're not a fan of the MCU films, they still make a ton of money just from the merchandising alone. You'd make millions from whatever Disney put out, and because you have the copyright, you can negotiate for more money. Of course, if Disney did lose, they'd probably just try to buy it back. They would throw out a dollar amount and call it a day. I would ask for Lucas money, $4 billion, and 15% of all merchandise money, and maybe some condition about final say on the depiction of the character, to avoid race swapping and gender bending nonsense. Would Disney take the deal? For Spider-Man? Yeah, probably. I mean, they bought Fox to get the X-People and Fantastic Four back. I'm willing to bet they considered purchasing Sony to get Spider-Man back before they made the deal to license him for the MCU films. It just depends on how bad they want it and whether they think they can make their money back in a short enough time to justify the payout. More likely, They're just going to try to prevent it from happening. And like I said, Disney has very good lawyers. I don't see them losing the suit for the copyrights anytime soon. Hell, they may walk out of court with the copyright to Ditko's name. Their lawyers are that good. But what do I know? I'm just some guy.